Good day, Mom. I am Jessica Gapay and we are the Loyals. And we are here to discuss about the unenforceable contract. An enforceable contract is a legally valid agreement that a court will not enforce. This means that even though the parties have agreed to the terms of the contract, they cannot be compelled to fulfill their obligation. Like, for example, missing important stuff. If the contract doesn't have all of the important parts like clear price, what it's about, and or what everyone agrees to do, it might not be enforceable. And another example, if the contract is from something illegal like selling drugs or gambling, it's not going to be enforced. And enforceable contracts have three types. These are unauthorized contract, statute of fraud, and ratification parties. These three types of unenforceable contract, which will be discussed of the rest of my group mates.
So, in relation to the three kinds of an enforceable contract, first will be the unauthorized contracts. This is with regards to paragraph 1 of Article 1403, which says that the following contracts are unenforceable. First, those entered into the name of another person by one who has given no authority or legal representation or has acted beyond his powers, unless ratified. This simply means na ang contract na nabuhat out of another person's name without authorization or legal representation from the person is unenforceable unless ratified. Usa pa sa dyan, magkaroon of legal effect. So, the governing law in case of unauthorized contract is Article 1317 and the laws on agency, in which Article 1317 says, no one may contract in the name of another without being authorized by the latter or unless he has by law a right to represent him. So, for example, without authority, akong gibaligya ang car ni Ate Jessica using her name adto ni Rosemary. Hence, the contract is unauthorized and has no legal effect because at the first place, waman ko authority. Ang effect is unless i-ratify siya usap pa na legal effect. Motong either expressly or impliedly, verbal or written or through conduct. So, while the laws and agency is when a person binds himself to do something in behalf of another, like the contract is through an agent and not directly by the person itself. And of course, the agent must have a consent or authority of the principal. And most importantly, ang agent dapat muak siya within the scope granted to him. So, for example, another example is, ako gi-authorize na ti Jessica to mortgage her car, pero akong gibaligya instead nga isang lara. So, mahog nga unenforceable gihapon ang contract nga akong gihimo. Because, bisan na ako'y consent, I acted outside the scope granted to me, then I cannot bind the principal and the contract is unenforceable. It is also important to know nga if an agent ni act within the scope of express power on behalf of the principal, then it means nga ang knowledge from the agent is also a knowledge of the principal. Simply means because an agent is an extension of the personality of the principal. Since the unauthorized contract simply follows the principle na ang person cannot be bound or ang contract is not binding when entered by a third person without consent, or if na ay consent, it must be within the scope granted to him only.
Today, I'll be discussing the kinds of unenforceable contract under Article 1403. So, ayon sa Article 1403 ng Civil Code, may mga kontrata na tinatawag natin enforceable. So, ibig sabihin, hindi pwede ipilit sa korte kung walang proper ratification or approval. So, nasa ito ka klase. Number 1, contract entered into the name of another by someone without or acting excess of authority. So, meaning, mauling kontrata naghimo sa katawag gamit ang name sa laing tao. Pero wala siya authority o lumagpas siya sa gihatag na kapangyarihan. So, example, ako naghimo ko contract gamit ang name sa boss. Pero wa ko gyatagan og consent or pahintulot na hot ng buhaton, so di siya valid ang contract. So, contract that do not comply with the status of fraud. So, ang status of fraud ay nagsasabi na may kontrata na kailangan sa written form para maging enforceable, tulad ng contract involving land or those that last more than a year. Example, kung verbal agreement lang ang usapan to sell a land, hindi siya pwede ipilit sa korte kasi dapat nakasulat o naka-written form. It's not enforceable. 3. As contract where both parties are incapable of consent. So, meaning, kung parang party wala sa legal capacity na magbigay ng consent, gaya ng minor o mga mental incapacity, then hindi rin enforceable ang kontrata. Example, dalawang minor, naghimo silang kontrata, invalid yun kasi pero silang walang authority na maghatag og consent legally. In additional point, a party may try to enforce the contract, but another party can use defense of lack of form or lack of excess of authority. Also, a third party cannot question unenforceable the contract under the Article 1403.
Good day, everyone. My name is Julius Bibera, and today I am going to discuss to you the Article 1317 Statute of Frauds. So, Article 1317 of the Civil Code establishes the Statute of Frauds, which aims to prevent fraudulent claims and ensure that certain types of contracts are documented in writing. This is to protect parties from false claims regarding agreements that were never made or misinterpreted. Contracts covered. The statute typically applies the following types of contracts. First one is sale of property. Any contract for the sale of land or real estate must be in writing. Number 2 is contracts not performable within 1 year. If a contract cannot be completed within 1 year from the date it was made, it must be in writing. Number 3 is sales of goods. Contracts for the sale of goods valued above certain amount, usually $500 or more, must be in writing. Number 4 is contracts in consideration of marriage. Any agreement made in consideration of marriage must be documented. Lastly, guarantees. Contracts where one party agrees to pay the debt of another must be in writing. Examples of Article 1317. Example number 1. In sale of real property. If person A verbally agrees to sell a piece of land to person B for $100,000, this agreement is not enforceable in court unless it is in writing and signed by both parties. Example number 2. In 1-year rule. If person C agrees to provide consulting services to person D for 3 years, this contract must be in writing. If it is only verbal, person D can refuse to pay for the services if C does not perform. Example number 3 for sale of goods. If person E agrees to sell 1,000 widgets to person F for $1,000, the contract must be in writing since it exceeds the threshold for the sale of goods. A verbal agreement would not be enforceable. Example number 4 for consideration of marriage. If person G promises to give person H a sum of money in exchange for marrying him, this promise must be in writing to be enforceable. Example number 5 for guarantee. If person I agrees to pay person G's debt to a bank, this agreement must be in writing to be enforceable. The next one is the explanation of the rule of evidence related to Article 1317. So the first one is the admissibility of evidence. The rule of evidence states that if a contract falls under the statute of frauds and is not in writing, it is generally inadmissible as evidence in court. This means that a party cannot enforce an oral contract that should have been documented. The next one is exceptions. There are certain exceptions where oral contracts may still be enforced, such as partial performance. If one party has partially performed their obligations under the contract, this may allow for enforcement despite the lack of written agreement. The next one is reliance. If one party has relied on the oral agreement to their detriment, they may be able to enforce the contract to prevent unjust enrichment. Examples of role of evidence. Example number one in inadmissibility of oral agreement. If person Key claims that person L agreed to sell him a car for $15,000 based on a verbal agreement and there is no written contract, person Key cannot present this claim incurred to enforce the sale. Example number two for partial performance. If person M verbally agrees to sell a boat to person N, and person N pays the deposit and takes possession of the boat, person N may be able to enforce the agreement despite the lack of a written contract of the partial performance. Example number three for reliance. If person O verbally agrees to lease an apartment to person P, and person P moves in and makes improvements based on the agreement, person P may be able to enforce the lease despite it not being in writing, as they relied on the agreement of their detriment.
So let us now talk about rule of evidence. So what is rule of evidence? So to prove a contract exists under the statute of frauds, the written evidence must meet specific requirements. This evidence often takes the form of written contract, but can also include several documents that together show the agreement's essential terms. So the writing must generally include identification of the parties involved, the subject matter of the contract, the essential terms and conditions, the considerations, and lastly, signatures of the parties being sued. And if a contract falls under the statute of frauds and is not in writing, it is generally inadmissible as evidence in court. This means that a party cannot enforce an oral contract that should have been documented. Now, let's have exceptions and waivables. So even if a contract falls under the statute of frauds, there are exceptions where it might be enforceable despite lacking a written agreement. These exceptions are often based on fairness and equity. So first is partial performance. So if one party has substantially performed their obligations under the oral contract, a court may enforce it even without written agreement. And next is promissory estoppel. So if one party reasonably relied on the oral contract to their detriment, and the other party knew or should have known this, a court might enforce the contract to prevent injustice. And the third one is admission. So if a party admits under oath that the oral contract exists, this can be sufficient evidence to enforce it. And lastly, waiver. So a party can waive the statute of frauds requirements by explicitly agreeing to be bound by an oral contract. So even if it should have been in writing, this waiver must be clear and unequivocal.
Next is the guarantee of another's debts. A special promise to answer for the debt, default, or miscarriage of another person must be in writing to be enforceable. This includes situations where one party agrees to pay someone else's debt if they fail to do so. The requirement for a written agreement helps ensure clarity and prevent misunderstandings in such financial arrangements. And the third is consideration of marriage. Any agreement made in consideration of marriage other than a mutual promise to marry must be in writing to be enforceable. This includes prenuptial agreements and other arrangement made in connection with marriage.
The law requires these agreements to be in writing to protect the parties involved and to ensure that the terms are clear and agreed upon.
Good day, everyone. I am Mylene Pigoson. I will be discussing about agreements for the sale of goods. Under the Statute of Frauds, a contract for sale of goods priced at $500 or more must be in writing to be enforceable. If one party denies later, it cannot be enforced unless there's some written confirmation or part of the goods were delivered or paid for. For example, if a store agrees to sell someone a furniture for $500, this agreement generally needs writing to be legally enforceable. However, if the buyers pay a $100 deposit and the store accepts it, even without a written contract, the agreement might still be valid up to the quantity of goods paid for. Next is agreement for leasing period longer than 1 year or sale of real property. Agreements involving leases over 1 year, sale of land or interest in land must be in writing. Oral agreements still valid. An oral contract might still be valid if there is evidence of part or performance such as taking possession or making improvements. Example, naay mi palit sa imong yuta, then musugot og verbal agreement. Unya, nagtukod og balay, then mi puyo, posibleng ang court dili mo enforce agreement kawa man mo written contract. Lastly, representation as to the credit. A statement where someone guarantees another person credit. Example, co-signing a loan must be in writing under the Statute of Frauds. Example, mupalit og car. Kung si A mosulti sa usa ka seller nga si B mao'y mobayad sa sakyanan ug si A mao'y mobayad kung dili makabayad si B. Ang saan ni A need a written agreement aron lig-on og mapatuman sa balaod.
Good day, everyone. I am Rosemary L. Polistico, and I will be discuss about the last kind of an enforceable contract, those where both parties are incapable of giving consent. From Article 1407 in a contract where both parties are incapable of giving consent, express or implied ratification by the parent or guardian, as the case may be, of one of the contracting parties shall give the contract the same effect as if only one of them were incapacitated. So, if both parties to a contract are incapable of giving consent, the status of the contract is an enforceable contract. When an enforceable contract becomes a voidable contract, if one of the parties, after attaining or gaining capacity to ratify the contract, so the status of the contract is voidable contract. When so when an enforceable contract becomes a valid contract. From Article 1407, Paragraph 2, if ratification is made by the parents or guardian, as the case may be, of both contracting parties, the contract shall be validated from the inception. So it means that if the ratification is made by the parents or guardian of by both contracting parties after attaining or gaining capacity, the contract is validated and its validity retroacts to the time it was entered into. So that's all and thank you.